Should you start with a patent, a trademark, or a copyright for your business? Hello Innoventors, I'm Karima, Gulick patent and trademark attorney, and today we're going to dive into just that. You have launched a business, or you've had your business for quite some time now, and you finally have the budget to protect your intellectual property, but you're not sure which one to start with. Should you start with that patent? Should you start with that trademark? Or should you start with that copyright? And the answer is always, I like to look into what's making your business unique. By looking at your top sellers, if your top seller is an invention, either a system, a device, a product, or even a method or a software application that you sell, then you want to start with the patent to protect that invention. The caveat with the patent is that you only have 1 year from the time you start disclosing that invention to people or sharing it with, including friends and loved ones, or from the time you start selling it to get that patent. After that 1 year from sharing it with others or trying to sell it, your invention falls into the public domain and you can't get a patent on that unless you've made improvements on it. Number two, if your secret sauce is really that branding, if you have a cookie store and your cookies are really delicious, but you can't really protect that recipe through a patent, but that branding is on point and people are going to you because they've come to love that crumbly feeling that is associated to your brand name, XYZ. People want those XYZ cookies because of that brand that they've come to love. In that case, you want to start with that trademark, protect that brand, and then eventually have an opportunity to monetize that, maybe start different franchises or license the brand to others to be able to use your mark. And then third, last but not least, is copyrights. Copyrights, if you are an artist, if you're doing sculptures, if you're a writer or an author, if you're an illustrator, if you take photographs, if you draw, if you film, if you sing, and if that's your secret sauce, that's your seller, you're selling your artistic work, then you want to protect that with a copyright. And lastly, I want to talk a little bit about timeline considerations. Patent is really the one that has that 1 year deadline after you start selling. You have to think about that because once that year is over, you've essentially given up some of your rights. So that's the one that really has like time sensitive urgency to it. The others do as well for different reasons. Trademark, you're essentially getting rights as soon as you start using that mark in commerce. That brand, use XYZ, for example, for your cookies. Once you start selling those cookies, you have priority, at least in that region where you are selling those cookies. So you want to make sure that you have federal protection and have priorities in other states if you have any consumers that are buying your goods from any other states, or if you have a website presence for interstate commerce. Lastly, the copyright. On the copyright, there is also some time sensitivity to it because if somebody infringes on your work, you want to make sure that you have a copyright registration before somebody copies you. What that does is it gives you access to damages. You're able to get additional damages and have your attorney's fees covered in case somebody copies you if you have that registration prior. Hope this was useful. I will see you guys soon.